You were Jose Castillo.
Yes, sir. Oh,
Mr. Castillo, you're charged with failure to stop, give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
thank you. The defendant was driving westbound on 9100 Willow Meadow at approximately 7 p.m. and crashed into a parked white Chevy Silverado. The defendant's right side mirror struck the left side mirror of the parked pickup truck. The complaining witness identified the defendant's vehicle with surveillance video and rode around the neighborhood until he located the vehicle. The complaining witness gave the address to the officers who went to the location. They met with the defendant, who stated he was aware he hit the truck, but was going to go back later.
This is a classic example of how a relatively minor incident can snowball into a much bigger legal problem. The judge isn't just hearing about the collision itself. The detail that stands out is everything that happened afterward. Once a witness starts describing efforts to track someone down and identify who was involved, the focus shifts from the accident to the conduct surrounding it. That's often the point where a judge starts paying much closer attention. Not necessarily because of the original event, but because the actions taken afterward can raise questions about responsibility, accountability, and whether the person involved is likely to comply with future court orders.
Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. You run his license, please.
Yes, sir.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance. If I find that something like this happens again, or if you pick up a new case or become a danger, I will revoke your bond and put you in jail. Do you understand, sir?
Yes, sir. So, Your Honor.
Okay. Mr. Castillo, do you have the ability to hire a lawyer? Okay, we're going to give you time. I'm going to have you go to Victoria, sign and reset. We will have you take your seat in the jury box while I get your bond conditions. Once you sign it, then you'll be free to go. Please.
All right, Judge, next, page 5, Contreras, come on up.
Sir, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. The defendant and the complaining witness were in an Uber on April 17th, 2025, when a fight broke out. The defendant jumped on top of the complaining witness. The complaining witness and the defendant were dropped off by the Uber driver at the complaining witness's house. Once at the property, the complaining witness attempted to go inside. The defendant started a physical altercation where he struck the complaining witness with closed fists, causing pain and injury to the complaining witness. The complaining witness was able to get away from the defendant and lock the door with the defendant outside. The complaining witness has visible injury and bleeding of the face observed by officers who arrived on the scene.
And is there alcohol or dope involved? Just pled to an assault a month and a half ago, and here we are again.
Your Honor, the nature of the relationship, it states, is a roommate of 2 weeks, and they were at a club known as Wagos on Washington Street. And, Your Honor, according to the dim summary, the complainant stated the defendant got too drunk.
We are now going to handle whatever issues that are arising with you. If I find that you're another danger to the community, I will put you in jail.
This judge is not known for handing out leniency like free samples at a grocery store. When he orders a scram device, that's usually a sign that the court has serious concerns about compliance and wants a way to verify that conditions are being followed. The scram monitor isn't just another box to check on a release order. It's one of the clearest indicators that the court believes close supervision is necessary. And pay attention when the judge starts asking detailed questions about employment, daily routines, and personal circumstances. Judges don't usually ask those questions just to make conversation. They're often trying to determine whether there's a pattern of behavior contributing to the defendant's legal problems.
You're ordered not to consume alcohol or illegal drugs, and I'm going to put an ankle monitor on you so I know that you're not consuming. You are not allowed to go to bars, nightclubs, anything of this nature where alcohol is primarily sold. Do you understand? So I'd like to put a scram on him. Okay, yeah. Waive the fee. You're not to have contact with the complaining witness in this case. If I find that you do, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? What do you do with yourself these days?
I'm taking care of him. Stepdad has taken away everything from us. So we're trying to figure that out. And that's why I moved in with Chris.
It's time for you to get a job. And I'm making that a condition of your bond. You're not doing anything and you have way too much time on your hands, so you're becoming self-destructive. This is now your second assault case within the last month and a half. No more. Do you understand?
Sir,
Can you reach out to the MAC for him, please? And then you're not to be in possession of weapons as well. I'm going to have you go to Victoria, sign a reset, and then we will have you take your seat in the jury box. You're going to have to get with them for your bond conditions, then we'll get you a lawyer soon. Good morning, Mr. Crenshaw. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 19, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. An officer met with the complaining witness who stated that the defendant has been staying with him off and on. The complaining witness advised that he came home and found garbage in the apartment, which the defendant denied having done. The complaining witness stated the defendant started recording him, accusing him of threatening the defendant. The defendant then put the phone in the complaining witness's face, and the complaining witness took the phone, at which point the defendant punched the complaining witness several times in the face, causing pain. The defendant then attempted to take an electric scooter, which eventually struck the complaining witness in the leg, causing pain. The officer observed the complaining witness to have multiple injuries on his face.
All right, Mr. Crenshaw, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with the complaining witness in this case and not to be in possession of any weapons. You understand? I don't see that a MOA or a protective order has been issued. Do you? You see a tray protective order?
The stipulations of my bond. I know that.
On Crenshaw, okay. I'm now entering in what's called a matchless order for emergency protection. This is a court order that identifies Mr. Montgomery as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes, sir.
If you violate this court order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up.
Yes, sir.
Do you understand? Do you have the ability to hire a lawyer, Mr. Crenshaw? Do you work?
Yes, sir. I'm currently looking for a job.
Okay, it's time.
Yes, sir.
We're going to make sure that that happens. So 2 weeks, I'm going to bring you back and I want to see what you have done to get a job. If you've done nothing, it's not going to go well for you.
Yes, sir.
You understand? All right. I'm going to appoint you a lawyer. I'm going to have you go to Victoria Center Reset. We will have you take a seat in the jury box. I'm going to get your bond conditions. Do not leave until you sign them.
Yes, sir.
You're not to have contact. You're not to be in possession of weapons. You understand?
Yes, sir.
Come on.
Let me take it.
Oh, hold on. Come sign for your protective order.
All right, Judge, next is page 6. Easy.
Hey,
Come on up.
can you file the no contact or weapons, please, on that?
Yes,
Mr. Crenshaw. Okay. Good morning, Ms. Woodward. Good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Okay. On April 17, 2025, in Harris County, Texas, a law enforcement officer made contact with the complaining witness who stated that she had a green light and the defendant's vehicle struck her on the driver's side. The complaining witness was transported to the hospital. A wheel witness stated that he saw the defendant driving at approximately 90 miles per hour and run the red light and hit the complaining witness's vehicle. The wheel witness followed the defendant, and the defendant stopped a few hundred yards away from the scene. The wheel witness stated that he believed the defendant was attempting to flee, but only stopped due to mechanical issues with his vehicle. A law enforcement officer came into contact with the defendant and noticed slurred speech, an odor of alcoholic beverage, red, bloodshot eyes, disorientation, and inability to follow instructions. The defendant admitted to driving. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, and the defendant refused the walk and turn and one leg stand. The defendant also refused to provide a specimen. A blood warrant was obtained and a blood draw was executed.
Judge, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand?
This is the part most defendants tend to underestimate. Bond conditions can look straightforward on paper, but they're often filled with obligations that leave very little room for mistakes. Random testing, ignition interlocks, alcohol restrictions, reporting requirements, travel limitations, every one of those conditions comes with consequences if it's violated. The mistake some people make is treating bond like freedom with a few suggestions attached. It isn't. Bond is freedom with conditions, and the court expects those conditions to be followed exactly.
Can you look to see any prior DWIs and if he has a license, please?
No prior DWIs and no license is eligible, Your Honor.
Okay. As long as you have a valid Texas driver license and liability insurance, you may continue to drive. But like I said, don't consume alcohol. Don't use illegal drugs. You will be randomly tested. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with her and she'll tell you if and when you have to come back. For now, we'll have you go to Victoria, sign a reset. You'll get the pre-trial for your bond conditions and then you're free to go.
Thank you, Your Honor.
Hey, I don't have the, bond conditions for the third driver, Thomas. Did you file conditions on Thomas as well?
I did, Your Honor.
You didn't? Okay. Maybe we just don't have it yet. The second offense, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a motor vehicle traveling at a high rate of speed. He observed the vehicle brake hard to slow down. The officer then got behind the vehicle and observed it to have an expired registration as of January 2025. A traffic stop was conducted and the defendant was identified by his Texas ID card. The officer approached the motor vehicle and observed the defendant in the driver's seat and the defendant to have glossy eyes, slurred speech, and an odor of alcoholic beverage. The defendant admitted to the officer that he had 5 to 6 beers prior to driving. The defendant stated he has a leg injury on his right leg. Standard field sobriety tests were conducted. A 4 out of 6 on the HGN, a 4 out of 8 on the walk and turn, a 1 out of 4 on the one leg stand. The defendant stated that despite his leg injury, he does work out and have an active life. The defendant stated he was a 5 out of 10 level of intoxication on a scale from 1 to 10. The DIC was read and the breath test strip was refused. A blood warrant was issued and the blood draw was executed.
Okay. Mr. Martinez, can you run his license, please?
Yes, Your Honor.
I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now, as a condition of your bond, not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you.
Yes, sir.
If I find that you're using, I will put you in jail. No more PR bonds. Do you
Yes, sir.
understand?
Yes, sir.
I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have one, I will put you in jail.
Yes, sir.
We are sending notice to DPS so that every single officer in this state knows that you're required to have an interlock in your car. So if you're caught wherever and you don't have one, officers will put you in jail.
Yes,
Do
sir.
you understand?
Yes, sir. Your Honor, can I speak?
Don't.
Because I got,
I don't want you to say a thing. Now's not the time. You have the right to remain silent, exercise that right. Just don't say anything. Don't. Do you have the ability to hire a lawyer, Mr. Martinez?
not a phone.
Deputy Miranda's going to give you an application. We'll take a look to see whether you qualify. I need to know everything about you, where you work, how much money you're making, how much money you have at the bank, what kind of car you drive, how many cars, stocks, bonds, mutual funds, everything. And then I'll take a look to see whether you qualify.
Judge, we have that the license is not eligible.
You are not allowed to drive. You will be signing an affidavit with me today, Mr. Martinez, and I'm telling you now, I don't give a rat's behind what your excuses. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This affidavit is what you're going to be signing, promising me you're not going to drive. Nothing in this world can justify you getting into a car and driving. Jesus comes down and needs to ride to church. Do not drive. You understand me?
Yes, sir.
Mr. Castillo,
Because you don't have a license, because you're not going to drive, I'm going to give you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming.
That's what I was gonna talk to you about. I was talking about my bond conditions.
Mr. Martinez, in the last 1.5 years, you have had 1, 2, 3, 4, 5. You are on your 6th case within the last 1.5 years. There's nothing at this time that you can try to negotiate with me. Do you understand?
I understand, but it's about work.
Stop. All I want is my streets to be safe.
Yes,
And
sir.
if I find that you're in danger, anything 1 iota, it's just not going to go well for you.
I understand.
Okay, do you mind giving an application and we'll have you swear to us?
Cool. Are you 45 Thomas?
Yeah, I can.
Oh, yeah, we never got Thomas's.
Gary and Thomas?
Yeah, I'll meet them.
Raise your hand.
Ready?
Mr.
Mr. Gallegos.
Daniel Martina Pedraza.
God bless him.
Good morning, Your Honor.
Page 9?
yes, Judge.
Okay.
Morning, Judge.
Hey, how are you?
It's very good.
Happy Friday, man.
Hi.
Did you say Marquina?
Martina Pedraza.
You, hey, this is now not the time for you to talk to him about this. You're Martina Pedraza.
Yes.
You're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to 1 year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 18th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle stalled in a moving lane of traffic. The law enforcement officer approached the vehicle and found the defendant in the driver's seat asleep with the vehicle running and foot on the brake pedal. The law enforcement officer woke the defendant up and noticed a mild odor of alcoholic beverage, slurred speech, and glossy eyes. The defendant admitted to consuming alcohol. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN was recorded. A 7 out of 8 on the walk and turn. A 3 out of 4 on the one-leg stand. The defendant consented to breath and blew a .157 and a .154.
Can you look at the eyes and licenses?
Yes, Your Honor.
So we, Marquina, to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using any alcohol or illegal drugs, I will put you in jail. No more PR bonds. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you because they sweep it hourly, if they find you, they will put a detainer on you and you will be stuck like Chuck in there until this case is over with and then you get shipped off to immigration. Do you understand?
¿Se lo entiende?
Yes, sir.
Yes, sir.
If you do not have a Texas driver license and liability insurance, you are not allowed to drive, and that is also a bond condition.
This ending is a masterclass in a judicial reality check. Notice how the judge isn't focused on just one issue. He's connecting all the moving pieces: immigration consequences, driving restrictions, bond conditions, court appearances, and communication with counsel. What might look like a collection of separate requirements is actually a single picture of the defendant's future. That's what makes these moments so important. The judge is effectively saying that the case doesn't exist in a vacuum. The consequences extend far beyond the courtroom and can affect employment, transportation, family obligations, legal status, and personal freedom.
Your Honor, we have no prior DWIs, but the driver's license data is not populating at all. There's no indication.
No indicación.
No license.
No license, Judge.
Dice no tiene licencia.
Do not drive, Mr. Marquina. You will be signing an affidavit with me today promising you're not going to drive. I don't care what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. Nothing in this life can you say that will justify driving. Do you understand?
Yes, sir.
Temptation is big. Just don't do it.
Okay.
So for now, I'm going to have you come up here, swear to us that you're not going to drive. We will get you to Victoria where you will sign a reset. You will eventually get with pretrial for your bond conditions, and after that, you'll be free to go. Because you have a lawyer, I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel, and he will tell you if and when you have to come back to court. If he tells me that he cannot get a hold of you because you're ducking and dodging phone calls, text messages, I'm going to issue a warrant for your arrest. If they call you to go take a drug test and you fail to appear, a warrant for your